All right, so this is workshop 2 of IP law. Our agenda tonight is mainly still housekeeping and making sure things are working and finding out where things aren't working. And the guide for this week was really around getting you to have a look at the IP Australia website. There's the reading on introducing IP law and to get that overview of the different major areas of IP law. Now, I could have just typed out a sort of summary in the guide, but I think this is one of these things that works better when you have a bit of self-directed inquiry. You can focus on the things you find interesting, and at the end of the day, there's always Wikipedia, which I probably, I didn't say that, but I think it's with something like the IP Australia resources are pretty good, and it's definitely worth exploring them rather than necessarily just reading a simple summary and spending some time looking at things and looking at some of the resources that are there. And one of the resources that are there that I've asked you to look at is the Victor Moa one, and that's kind of significant to what we'll be talking about later, because they have quite cleverly managed to combine pretty much every area of IP law into one product, and including plant breeding rights, which don't really apply to the mower, but I'll give them a pass on that one. And one of the things I want to get across from tonight is that idea of overlap, and that idea that in pragmatically there's all kinds of things that can fall into products that can fall into multiple areas. We'll look at some of those, and to also look at IP law as an area that's quite strategic. It's not like, say, criminal law, where you say, was there assault, wasn't there assault, was there an assault, was there intention? You filter it through a forensic process, you figure out if you can prove it or not. IP law is really strategic. It's about figuring out what your rights are, what you want, and then trying to leverage the best kind of response or the best kind of outcome for your clients. And in week 10, I think, we're going to look at some of the dark side of that, and we'll look at IP trolls, who are, people who are sort of bottom feeders in the world of IP law, that are about as noble and upstanding as Saul from Breaking Bad. Okay, so there's a set of questions in the outline in terms of things you should be more confident about knowing. So what is the purpose of each of the areas of IP law? What's the legislation that governs it? What are the kinds of property that are included, excluded? What period is it regulated for? Is registration required, or is it automatically property? And who can initiate legal action? So once you've got those basics for each of those areas, and the four big ones are copyright, patents, trademarks, and designs, then we're good to go. And we'll start through the rest of the course zooming in detail and some of the contentious and controversial areas in each of those. Because I don't see myself that there's a whole lot of point in just going through all the legislation relating to any particular area of law, in case you might need it one day, because if you're going to forget it within 5 minutes. So what I think the best approach is to really focus on the things that are controversial and things that are interesting that we can actually have a discussion over. So that's what I've attempted to do with this course. And you can probably hear my dog having a drink, and he's having a very long drink, and I keep thinking he's going to stop. Cordo, he's going to run out of water eventually. Cordo, thank you. All right, so those are the sort of things we're going to look at. There's a couple of housekeeping things, I guess, around the course that I need to cover. One is the timing for the Zoom session. It's looking like going to be this time slot. There was one, there was one more person who went for Wednesday night than Tuesday night, but it was a close call. And I've just picked up a couple of obligations on Wednesday nights throughout the term. So it would mean those weeks would have to do it on a different night anyway. So I think I'll put in a regular Zoom session for this time slot each week. Now, throughout the latter part of the semester, there'll be presentations, which is not as formal as it sounds, because really I'm just asking people to take the lead on the discussion. It's not like a really formal thing at all, although of course you will be writing a report, which will be a more formal assessment piece. Now, some people may find they can't attend the night that they've got the workshop, so I'm probably now talking to people who are not here at the moment, who are watching this as a recording. If you're in that case and you really, really, really can't make one Zoom session throughout the semester, have a talk to me, get in contact, and we'll find an alternative. Now the dogs are playing because they think this is all very new and exciting. Okay, so yeah, if you are really in the situation where you can't, thanks, Grant. I'll come back to that in a sec. If you are, and I'm sure I'm talking to people in recording land out there, you really are stuck and you really can't make this time slot at all, we will find out a way, because you can interact with the forums, you can record a video for us. There's lots of things we can do that we can make sure that you make the session. Because I'm conscious of the fact that as distance students, these Zoom sessions are not compulsory. However, they're really useful, and it's really important to get into debates and discussions, because if you learn just by yourself, that's not a, it's not a fantastic experience. Okay, so I will set up the recurring Zoom meeting for Tuesday nights. If you haven't already nominated a workshop that you want to do, please get in and nominate as soon as you can, just so we get an idea of what the spread is and who wants to do what, and you have preparation time. In terms of the materials, I am finally in the final stretches of week 11's notes being finished and sent off for editing. Sorry it's taken so long to get those out to you, but I'm working as fast as I can to get those notes together. The next thing I will do is to do the rubrics for assessment. So you've got those, so you know what you'll be graded on. The criteria are already there in the course outline, but I'll do a breakdown for sort of pass credit, higher, what sort of things I'll be expecting for those. Okay, Michael's got a question after recording's done. That's fair enough. And Natalie's still can't nominate a workshop. Look, IoT haven't gotten back to me. I know there's been a cyclone and everything, so I'm trying not to be an arse about it. But there is something definitely strange about this new version of Moodle. What it looks like to me is that it's only the forums that are, it's only affecting the forums that are in that top block. And what it seems to be is students can't reply to questions in those blocks. However, bizarrely enough, you can actually post a new topic. So the people who've gotten around, who've managed to post their workshop topics, what they've done is they've just gone into that block and got, instead of saying reply, which is what I asked you to do, because forums are supposed to be something you can reply to, I think. What those people have done is just posted a new topic and just posted new topic, workshop 8, I want to do workshop 8. So have a go at that. If it still doesn't work for you, let me know and I'll put something in there on your behalf. But we had a similar problem with news. Margaret sent me some details on some interesting workshops that are coming up on copyright and couldn't post them in the news forum. So I posted them there myself. So we need to track this. Okay, so Natalie, if it's not working, if you send me an email and let me know which one you want, and I'll just and I'll just stick it, put it in for now. Now, I'm aware that not being able to access forums is going to kind of limit our way of interacting in this course. So I'm trying to track down the problem, but like a lot of tech problems, it's like sometimes it works, sometimes it doesn't. As far as I can tell, the forum topics under each of the weekly areas don't seem to be affected. You seem to be able to post new material and reply. And Grant's just suggested the news has always been restricted to course coordinators, which is just insane. I suppose if you are teaching in a classroom full of desks in rows and hitting people with a cane, maybe you don't want students posting things in the news group, but that seems to be mental. But I'm not saying that's not true. It could well be true. That could be the problem. So I will continue to post, put new forum topics in other areas. It may just be that. The thing that makes me curious though is with the nominating the tutorials one is that some people have been able to nominate a new topic. So I would have thought if it had been locked down to course coordinators only, and you weren't wanting students to reply, the last thing you'd want them to be doing is be posting a new topic. So why is that working? Who knows? So it's teething troubles, new version of Moodle. Long story short, we will work around it. Fortunately, this is a small subject. I don't know what the people with 400 students in their subjects are doing. Probably going insane. There's a few topics each week that I'll be posting discussion forum points on, and yeah, we'll see how it goes. And if there's something that you would like me to create in there that's not there, I can certainly have a go at that as well. Now, I don't want to get too far down the chat window. Grant mentioned earlier looking at the IP Australia site and looking for registered designs. So Grant said he's looked at the site, looked for registered designs of motor vehicle bodies without success. Are they usually registered? There's sort of two parts to this problem. One is it's actually quite hard to find things in the registered design database. So sometimes you search for things that you know are there and it can be hard to find them. And we'll talk about that in week 8 or whenever we come back to it, about some of those problems in the designs area. The other part of the question is a lot of things that you think would be entitled to be registered designs, they just don't register. And that's also an interesting question. And it's a strategic question as well. Because one of the weird quirks, and we're jumping well ahead here, one of the weird quirks of registered designs is you can't register something you've published. So you've basically got to develop something in secret, register the design, wait for the registration process to take place, get confirmation, and then go public with your registered design. Now, in a lot of areas of product manufacturing or whatever, you just can't do that. You know, if you're working for Holden and you've got a new car that's coming out, you generally probably don't have the lead time to put in the registration of design and wait and see what happens. The other thing is, and there's a really interesting video I found on Fashion where which discusses the fact that sometimes you don't really even want to protect designs. And in fact, if someone copies a feature, it's actually sometimes an advantage to you because you get to be the design leader in the field. So if you design us like a certain new style of taillights go through all sorts of fashions. They seem to be the thing that changes most on cars. You design a new style of taillights. We're not going for round taillights. We're going for sort of elongated Japanese mecha style taillights, and everyone else starts copying you. You don't really care so much that they're copying you, and in fact, you get to say, look, everyone's following our lead. We're actually the lead designers in this field because our innovations, when we introduce them, are what everyone else follows. So it's a really complicated area, and this drives some law students crazy, I must admit. Some people who are used to law being at least seen to be more certain, where it's like, well, what's my legal rights? What's the cases? What's the facts? How do I apply them? What's the result? IP law doesn't work like that. And what I think you'll find is that most areas of law don't work like that, even things that appear on the face of it to be really simple. And we like to teach them in a way that's kind of abstract and sort of simple. At the end of the day, it's all about negotiation and strategy and thinking and planning. Now, for me, that's the good stuff. That's the stuff that's really interesting about law. But I also appreciate there's a sense of vertigo that comes with that for some people, that they feel kind of disoriented, because you go from this nice idea of certainty where everything's regulated and there's an answer to all the problems to suddenly going, but if that means, but what, hang on. Yeah, I appreciate that can be a bit of a crisis of faith.
Is the rationale behind that is simply that you can't patent or trademark something which has already been released to the public because it then becomes public domain, and tracing that back to the person who originally came up with that concept is just too much of a legal minefield. So basically, if it's in a legal domain, in the public domain already, then that's it. I mean, if it got leaked or whatever, too bad.
It's only the registered designs that's a problem for. So things that are copyrightable are automatically copyrightable. There's no registration, although they used to have to be registered way back.
What about patents and things like that? So you got a patent on a particular car engine, and that gets released all over online. Can you still patent that car engine, or is that now in the public knowledge?
I think you can lose it. Patents are a bit more like designs. You have to. One of the weird things about patents is the registration process involves disclosing your innovation. So it's not a design feature as such, it's an innovation. It's more of a technical idea for a patent. But the trade-off is you get a limited monopoly over it for a certain amount of time, but you have to be able to disclose to the rest of the world what it is, how you've done it, so that when the patent period is over, everyone can access it, which is why there are a whole lot of, you get waves of new medication. Xanax or something Xanax may have just come off of its patent period, and all of a sudden there's a whole lot of generic medication that suddenly appears because the formula for Xanax is part of the patent, which is why Coca-Cola has never patented Coca-Cola, because they'd have to disclose how it's made.
So the reason that is in place is basically because it's for the betterment of society as a whole. That's the trade-off.
Yeah, and IP law is all about trade-offs. And this is why people are very angry about people like Disney and corporations that keep lobbying to have copyright periods pushed back, because the trade-off is supposed to be for copyright that you can benefit from copyright for your lifetime, and then it goes into the public domain. The problem is corporations don't have a lifetime.
I was about to ask, how do you measure the lifetime of a corporation?
Yeah, so it's the lifetime of the original designer, and now it's the lifetime plus 70 years or whatever. But the problem with Mickey Mouse keeps being in peril of falling into public domain. And I think Mickey Mouse is coming up again, and Disney are going to have to start making major campaign funding contributions to politicians and things to have the laws changed again.
Isn't that kind of a pointless exercise though? Because it's such a big brand, isn't it? When you see Mickey Mouse, it's automatically synonymous with Disney. So it's not like, or is it because if you stick Mickey Mouse on a T-shirt, you have to pay them royalties as long as they have the rights to it? Is that kind of the reason?
Yeah. Yeah, and they don't necessarily want, and this is one of the themes I try to get in this bring out in this course is and it's also about keeping their brand untarnished. Yeah, it's that goes into my background is also in censorship, and there's all sorts of interesting things about tarnishing people's brands. Yes. Anyway. One of the problems with intellectual property is that ideas aren't property. And what the law has basically done is taken a legal tool, which is property law, and said, we've got a social problem. The social problem is creative people are not getting remunerated for their work. Other people are exploiting them. What do we do? And this really interesting experiment took place under the Statute of Anne, where they said, well, maybe we'll call this stuff intellectual property and maybe we'll find a way of protecting it. But it was never a really good fit. What happened with the Statute of Anne was the Stationers' Guild controlled the printing presses in London. It was, the internet of its day. This was new technology. And they were just finding books that ordinarily would have to be hand copied, and they were just printing massive print runs. And by massive print runs, I'm meaning probably 100 for that era in history. But it meant that all of a sudden the people who owned this new technology could just cut the authors out of the deal altogether, and authors were getting nothing. So the Statute of Anne invented copyright. It was the origin of the original intellectual property law, and it was one of those rare cases of the law being really, really innovative and really, going out there and social engineering and trying to fix a problem. But it's not a completely good fit. And that's why we have problems today. It's why there's problems in terms of things like Indigenous art, because our Western ideas of property don't translate into other cultures, and they don't even translate all that well to our own culture. We talked about blues music before, and the idea that, someone can own a blues riff or own a phrase is alien to that idea. So anyway, there's a whole interesting set of sort of social and cultural things around IP law that I find absolutely fascinating, and I appreciate this will probably bore a lot of people who are saying, I'm just here to get the information, find out what the law is and get out. But that's okay, because these discussions aren't necessarily for everyone, and hopefully there's enough variety in this course so there's something for everyone to do. So yeah, and the point about brand protection is another interesting one. It is more of an issue in trademark, because trademarks are, again, not really technically a form of intellectual property, although we usually call it intellectual property. This is such a wishy-washy area sometimes. But there's a requirement for trademarks that you defend your trademark, and you can actually lose a trademark if you don't actively defend it, which is why people whose, again, we'll come back to this, but people whose properties whose brand names become synonymous with the product don't like that happening, because they can actually lose their trademark. So people, not so much here, but I think in Britain, talk about vacuuming as hoovering. And when that can happen, you can actually lose control over something being a hoover, because it falls into common use, and then anyone can use it, and then people can use it with poor products as well. And we'll go through that. There's a whole lot of brand names that have become generics. Ephedrine, which is adrenaline. Adrenaline is a brand name, I think, or I got that around the wrong way. I know heroin's a brand name, and that's someone that they've lost. Not only have they lost the right to legally produce heroin, but they've also lost the the control over the trademark of heroin. So
I would hope so. I remember all those old, like, you look online, you can see old ads for heroin. It's like, put your kids to sleep, so they get good night's rest. Give them heroin.
Yeah, and we talked about Coca-Cola's secret recipe before, and the coca leaves are the same derivative of cocaine. So yeah, anyway, we're jumping ahead on a lot of this stuff, but that's okay, because we're sort of, aspirin. Aspirin's another one. I should remember this because it's only a week or so ago that I typed some of these out into your course notes, but once I write things down, they go straight out of my brain again. All right.
Champagne's not a brand name. That's a region in France.
Yeah, that's another area, is regional, but again, it's not really IP law. It's more, it's more.
I think the region came first.
there's stuff around geographical indicators, and basmati rice is another one. I think you can only call something basmati rice if it's produced in the basmati area. And this is, again, it's not even really IP or trademark. It's about it's about geographical indicators and about sort of trade treaties and agreements. So we not do. I haven't put a lot on geographical indicators in the course, largely because it's not an area I'm hugely familiar with. But I can certainly we can look at some of that if people are more interested in it. But it's one of those things that's only happened relatively recently, and so in Australia it's not quite the same thing. But we have like a series of regulatory laws around made in Australia marks and wool marks and things like that. So if you put the wool mark brand on something, there's actually legislation that says you have to comply with it actually being wool, and you can't just stick the wool mark on it. And there's the Made in Australia logo is another thing that is actually penalties for misusing it when it's something that's not made in Australia. And the geographical indicators are a bit like that. So again, there are regulations around various foods and products that are synonymous with the region, and champagne was probably the most famous. Basmati rice was another one. But I can dig something up and stick it on Moodle. In fact, I will make a note of that, because if you guys are interested, it certainly means it's worth spending a little bit of time on it. And again, you know, the IP law is such a hybridized area. It deals with a lot of these things are thrown in, and it's not really a form of intellectual property. It's actually a form of trade regulation. But we kind of say it looks a bit like trademark, so we'll kind of stick it in there. The other thing that we need to sort of, will tie into some of these topics, is some of the other areas of law that connect back into IP law, and there's some torts that are related. So the really big one is passing off. Do you remember that from torts? Okay, passing off. Some do, some don't. It's one of those things. Just check out the Wikipedia entry on it. Just you only need to be notionally aware of it, unless we and we'll look at it in more depth in a certain context later on. But passing off is one of those, and there are a lot of weird torts out there. And look, I don't know about milk labelling. Again, it's one of these things that there's all this legislation about food and product labelling that's kind of not IP, but kind of related. But yeah, passing off is where you, it's a personality tort, and it's where you imply someone has endorsed, supported, or is related to your product that isn't. And the classic case was someone who was a golfer who had a chocolate bar in his pocket, and they used the picture in advertising and said, Mr. such and such, the golfer, supports fries, chocolate, whatever. And he said, I never did that. They never paid me for support. I never volunteered support of it. I just happened to have a bar in my pocket. And that was considered to be passing off, and that's where you are unfairly trading on the personality of another. And it tends to be celebrities, and it tends to be, it's almost like, you know, torts are attacks or harms. It's like you're kind of attacking or harming someone else's personality, celebrity rights. And again, we'll come back to it, because we may be evolving between the law of passing off and the tort of privacy. We may be evolving a tort of celebrity or a tort of personality, and that's all kind of churning up and happening at the moment. Once it was believed that once people were celebrities, they put themselves in the public view, and they were fair game. We're increasingly coming to the point where celebrity is seen as like a marketable resource that you should be able to control and sell to whoever you want to sell it to, which is kind of bizarre, but we'll come back to that. So we're passing off it also blends a little bit into sort of false advertising and false and misleading advertising as well. But it's usually when you're trying to glom onto someone else's goodwill. The other thing that happens with passing off is Aldi. And how does Aldi survive being attacked for passing off? I've got no idea. When you produce a product that has very similar packaging to a leading commercial brand, and you basically it's seen as you're misleading someone, that your Fim Fams are actually Tim Tams, and they get mistakenly buy them, and it's I guess it's almost like stealing goodwill. That also comes into passing. We do a whole lot of this later in the course because it's fascinating, and I do raise the question of how the hell does Aldi get away with it. Partially, I think it's because no one goes into an Aldi thinking there's going to be real products in the shop. Although from what I saw in the paper recently, you probably should be aware that you might get maggots and fingernails and things in your food. There was a whole expose on Aldi recently. How do they make their food so cheap? Well, it's all fingernails and maggots, apparently.
I'm curious to read if there has been any cases brought against Aldi for passing off. I mean, I haven't heard of any, but I wonder if they're out there.
Sometimes it's because the same manufacturers manufacture the same products, the generics and lead brands. I know Arnott's they produce the Arnott's biscuits and then they run another run of the biscuits and put a different packaging on them and sell them as the not quality brands. So, yeah, they get 2 bites at the market. They get to sell it once and then they get to sell it sort of half the price and they still make a profit on it.
I knew they did that with milk, like with the $2 milk at the Woolies, and then the $5 milk is like from the same place. But I didn't realize it's so pervasive.
Yeah. So I think there's a bit of that goes on with the generics, is they don't want to sue because it's the same people producing them. The other thing is they may not consider it to be worth their while to drive Aldi out of business because they may just think that they're a different market and people who are going to shop at Aldi are not going to go and buy the name brands anyway. I'm not sure, but we're going to explore that later on because I find that stuff fascinating. And again, if you're the kind of person who likes your law black and white and cut and dried, it's going to drive you crazy because it's all guesses and suppositions and interesting strategies. And it's not something that we can say, well, the answer is you look at section 56, 7, subsection B of the legislation, and it tells you what the answer is. Anyway, back to torts.
So as a lawyer bringing a case in IP for a client, are you kind of going into is it like going before the High Court? It's almost talking in terms of philosophy. You're not quite sure which way it's going to go. You know, there's less certainty about how things are going to turn out.
There's zones of certainty. So there's areas that we're pretty sure which way, and I guess that happens in any area of law. If it gets to the High Court, it's usually because there's a zone of uncertainty around it. But a few years ago, Sony took litigation over someone who was modding the PlayStation 2s, I think, at that point. And it went all the way to the High Court, and Sony and I saw some of the case, not because I'm a colossal IP nerd, but I just happened to be in Canberra at the time and thought, hey, I might have a look at some of this. And Sony was so certain they were going to win because he was a shonky guy who was chipping their system so people could play pirated games. What they didn't guess was that the High Court would latch on to the fact that Sony had differential price points and Australian consumers were paying about twice as much for games as American consumers. And what the copy protection was also doing was creating this limited market of exploiting local consumers so they couldn't just parallel import the same product for a lesser price. And the High Court actually held against Sony. And it was just amazing watching the turnaround of the mega corporation going, oh, we've got this. This guy is so shonky. He's working out the market. He's chipping things so people can play pirate games. There's no way we're going to lose this. To the High Court turning around and saying, well, actually, guys, how come you're charging Australians twice as much for the same product? And, you know, isn't it fair enough that this person has chipped these systems so people can play games they have legitimately bought from a different market? And sure, pirate games as well, but we're going to decide that that's only a subsidiary thing and it's only a minor part of the case, and we're going to focus on that. So, yeah, I think anyone who says that law is kind of predictable, it's kind of half of the case. Law is predictable and stable in the centre, but at the edges, it's really, really volatile, and things can change really, really quickly.
Is that why when they're talking about like downloading piracy currently in Australia, they bring up the punters bring up over and over again accessibility and affordability? Is it because of that case that you're going to have less certainty as a distributor if you're not affordable and as accessible as in other countries?
Yeah, and there's a whole again we get another one we're going to come back to about attempts to regulate what they call the grey markets, where they sell really cheap products in Southeast Asia, then people parallel import them. I'm going to quickly jump back to the questions. How deeper understanding of confidentiality is required? We're going to look at confidentiality, or at least part of confidentiality later on. So we're going to return to that. Where there is one area, and I'll quick preview of where confidentiality is really important. Copyright only protects the written, the material expression of an idea, not just the idea. So if I say to you, I've got a great idea and tell you it, there's no copyright protection. If I say, I've got a great idea, I've written it down here and tell you about it, it's protected under copyright. So if you don't form it into material form, confidentiality can provide a remedy if the relationship under which I tell you about that idea is a confidential relationship. And where this occurred relatively recently was someone pitched the idea of a quiz show or reality TV show to a TV station, stupidly didn't write it down, TV station produced it and said, sucks to be you didn't, it's not copyrightable. And the courts found they had a remedy in breach of confidence, because they said the meeting was a confidential meeting by looking at the context, and they breached the confidence by going off and producing it. So that's about as far as we need to go with understanding confidentiality. There needs to be a relationship of confidence, there needs to be a breach, and there needs to be an injury that comes from it. So don't sweat the details too much on that one. Okay, can IP fall into two categories, trademark and design? Yes, and the forms of protection are different. So make sure you have a look at the IP Australia stuff this week and start to develop the idea of the nuances. So a design, for instance, can be copyright as a creative thing. Design's a bad word to use because designs are registered. An image, a drawing, okay, can be, it's copyright. It can also be applied to a registered design. So I can design a laptop case and I can stick my drawing on it. And the laptop case, the practical design features, that might be registered, but it might also have my copyright image on it. The image that I've drawn might also be a trademark if it's applied in relation to a product or service. So those things overlap, and the Victor Moa is a great example. So have a look at the IP Australia site, have a look at the Victor Moa, and it's a cute little interactive tool where they look at the different forms of IP that can relate to it. Trademark is to be sought that features the design. Apply to reach the design first, apply for the trademark, is what the reading said. The reason they're saying to design first is as soon as you make it public, you can't register a design. That'd be why they'd be saying that. And even if your publication is applying for a trademark, you might find you've lost your ability to register as a design. I'm not sure, and this is my prejudice as a literary / artistic IP person, not a designer. I'm not sure how much protection of design goes on. But that is going to be a very interesting thing for us to talk about later on. I think it's probably mainly when it's to stop competitors mass producing something that's similar to your design, but it probably doesn't stop people making a whole lot of knockoffs somewhere internationally and importing them. I think is probably it's probably the where it doesn't work. So for instance, IKEA, I'm sure, register all their designs. And if Kmart decide to produce something that looks very substantially similar to an IKEA table, IKEA would probably have words with them about it. I should check actually whether IKEA do or not. They may not. But someone who produces makes a whole lot of cheaply produced tables and imports them through, dollars for less or whatever, probably there's never going to be any litigation around that for various reasons. Okay. When did IP Australia sort of stories on Shark Tank? Yeah, I saw that this week. That's something new that they're putting up there. They're putting like a commentary on the Shark Tank series. They're doing really good things there. And I mean, I must admit, as one person working as an academic, I don't have the resources to produce this stuff, which is why I'm pushing you in their direction rather than textbooks. So yeah, that's probably worth keeping up with. Moral of the story, check first. Yeah. And I guess that's, as advocates, what we're all about is coming up with good strategies for checking and thinking ahead. Many designs would be branding. Branding is more trademarks. So Cadbury's purple is a trademark. Harley Davidson's sound has been trademarked. The sound of the muffler with holes drilled in it that Harleys make. So it's not really a muffler so much. There's some really odd stuff that can be trademarked, and there's a debate at the moment about whether you can trademark a smell. Obviously going to have huge impact for the perfume industry, because there's a whole lot of perfumeriers who sell their ability to produce copies or reasonable facsimiles of well-known perfume brands. So that's kind of fascinating, and I can see two sides of that. On the one hand, I can see how the hell can you trademark a smell? On the other hand, I can see, well, this is a huge business, and people invest.
Even if you could, it'd be impossible to regulate, because how the hell do you record a smell?
Yeah.
And even if you could, you would deteriorate, or it's subjective as well. How do you record a subjective feeling? I mean, oh God, I couldn't do it.
Yeah, I guess at least like the Cadbury purple, we can just have a look at the two purples and we can look at them next to each other. I could just imagine a jury trial. I don't know if these things are heard in Australia with juries or not. Possibly not. We can imagine the judges sitting around with bottles of perfume, going, increasingly pale in the face, sniffing each of them and trying to figure out if one smells like the other one. And yes, the chemical compounds. Again, with chemical compounding, we're there in the world of patents, because patents are about the compound and the process. So if you can actually show that you have a patented process for producing a particular smell and that's been infringed, you're kind of more in the patent field, although I guess the actual process for producing smells is public domain for most perfumes, I'm guessing. It's technology that goes back to the Middle Ages, so I'm guessing, it's so it's an interesting and emerging field. It's one of those things that, on the one hand you can see, it's a person's business, they probably should be able to protect it. On the other hand, what are the pragmatics of actually doing it? And again, foreshadowing that the video, the TED Talk I found on fashion is really interesting, because it looks at why the lack of IP protection over fashion, although it technically could be a registered design. And I found in the mind mapping thing I did this week, a particularly fetching pair of studded jeans that have been registered as designs in the Australian database. Technically, some fashions could be registered designs, but the fashion industry itself benefits from the lack of protection, because it's all about being first. It's all about being the one who's seen as an innovator and other people following. So you want people following and copying you in the world of fashion, which is counterintuitive to us when we think about things like copyright. But it may not be that way. It may well be that, musically, being seen as someone as an innovator that other people copy could be more valuable than being able to say, I invented dubstep and I'm going to stop anyone else, being able to create dubstep music because I own that. Music may be have more in common with fashion. I'm conscious of the fact that I'm rambling a little bit. I talked about torts, passing off, privacy, even defamation, maybe. There could be stuff around IP and brands and identity there. Misrepresentation, definitely, where people suggesting a product has features that it doesn't, and negligence. And one thing I have not put in there, I'm making a note of, is regulation of advertising and corporate conduct, because those are other areas of law, not torts, that can intersect as well when you've got false and misleading advertising. So I'm hoping I'm not confusing everyone at this point. And I just caught up with the chat window. Honestly, realistically, for our outcomes of this week, if you are pretty certain that you know your copyright, your patents, your trademarks, and your designs, we're good to go. You don't need to know those in absolute depth. You don't need to read 1,000 pages of textbook on it. You just need to know what they are and how basically they work, and we're pretty much good to go for the rest of the course. We didn't really get onto the workshop exercise as such tonight. We'll do better in future, I'm sure. Now, I guess we're sort of in the last 10 minutes or so, so have a think about whether you've got questions to ask, or things that I haven't made clear enough, things that I could give you more resources on. One thing I have become aware of recently is a TV show called Halt and Catch Fire, which is about the computer industry in the 1980s and the production of the first IBM clones. And I've seen the first episode of it, and I'm not going to tell you how I obtained the first episode of that to watch. But if you are interested in IP and computers, it looks like being a really, really interesting series, because it has the weird, convoluted way they get around, they got around the IP protection of the IBM chips in the series. So it's a drama, and it's interesting in itself, but the way in which IP is treated is really, really interesting. I'm pretty sure it's called Halt and Catch Fire. Let me quickly. Shush. Porno. Sorry, someone wants to contribute. Yeah, it is Hold and Catch Fire, which apparently were old DOS commands where you could cause a program to freeze. If you said Halt and Catch Fire, it wouldn't. Your computer wouldn't actually catch fire, but it would actually crash the command sequence. Anyway, that's a really incredibly intensively complicated and technical description of what that means. And the series has Lee Pace in it, which may mean something to you or may not. But Lee Pace is pretty cool. And some other folks. So yeah, I'm going to talk about Halt and Catch Fire somewhere week further down the course. But if you are interested, it might be worth trying to catch up with episodes now, using whatever completely legal and above board channels that you have of getting access to those episodes, because I wouldn't be a hypocrite about suggesting otherwise. But I reckon it's probably going to create some really interesting discussions further down the track. All right, now I don't know that anyone is put themselves down to do the workshop for next week, but that's okay. We can all be involved in that one. Next week we're looking at someone said they are going to do it. Cool, that's fine. I'm going to have a bit of a think about what's the best way of doing a timeline. because what we'll be looking at is the timelines of media technologies and the invention of new media technologies and the changes to IP law that attempted at least to keep up with those changes. What I'm thinking is the easiest thing may just be a Google Doc, and we'll just do a big table, and then if it's a Google Doc, everyone can actually get in and edit it at the same time, and we can add new rows as we add new eras into that. So that's what I'm thinking. I might just set it up as a Google Doc, and then while we're in Zoom, we can actually be in editing that as well. And that's probably going to be one of the best. I'm always looking for good ways to collaborate on this stuff. Otherwise, you know, always available via email. Well, not always, I'm not going to lie. I don't check my email over the weekend, but throughout the week, available via email if you have questions. The materials are finally coming together. Sorry, there's been delays on those. Rubrics will be there. You'll also notice in each of the weeks there are key concepts which give you links to basically empty Blogger pages. Now, that's because I haven't developed this stuff yet, but the idea is I want to start developing resources around each of those key concepts, and I want to develop them outside of Moodle, so it's something that you can access later, so you don't have to be enrolled in the course or at CQ to have access to. So the things are always there. So this is the first time that this has been done. At the moment, I'm just setting these things up, but as time goes, I'll start adding more and more resources there as I find them. So if you've seen those and you're confused and you go, I clicked on the link and all it goes to is an empty Blogger page, don't worry, because those are things that are in development at the moment. Okay. Tuesday, 7 Queensland time. Yep. Next week I will lock the dogs in another room so they don't feel the need to be involved so much. Otherwise, see you folks later. I think I'll stop the recording now.